Hey, what's up, y'all? It's Hookah Anonymous, and you are now rocking with Mickey Truth. She live up to her name, not the fame. So make sure y'all subscribe to her channel and stay updated on what's real. Bye.
Coming from where I come from, they doubted me, but I came up. I made it through the storm, trying to conquer the world. I made it through the storm, trying to conquer the world. Coming from where I come from, they doubted me, but I came up. I made it through the storm, trying to conquer the world. I made it through the storm, trying to conquer the world.
Good reporting ass Mickey.
We love you, Mickey.
What it do, Truth Team? Y'all, listen. Your girl is sick, okay? Sick as a dog. My body aching. I've been sick for the past 2 days. I feel like death right now. So bear with me. However, I wanted to go ahead and drop this video or this live because I can't even do no video. So yeah, my whole house is man down right now, okay? So y'all bear with me. Born on what's up. Listen, I got no flu. I have never had the flu ever in my life before, okay, until now. And when I say I done had COVID a couple times back when it first hit, it ain't got nothing on this flu. I tell you, like, I feel just weak, okay? This is not gonna be a long live. However, like I said, y'all, I could not even get the strength to even try to record, edit, nothing. So I said I'm just gonna come live to give it to y'all because I want to give it to y'all first because it's definitely gonna hit next week sometime. All right. Happy New Year to everybody because y'all know your girl is gonna be knocked out. Okay, I done took my medicine, so I'm gonna get to talking before it kick in. I'll be over here in the middle of live. Timothy, what's up? Okay, so all right, let's get into it. Y'all already know everything on this live is for entertainment, educational purposes only. All information used on this live is per the Fair Use Act, and any conclusions that you draw is on you, not me. Okay, I will not be showing paperwork. However, I'm gonna walk out through it once it has been officially made public. I'm pretty sure everybody's gonna pick it up. Yeah, let's get into it. So, as y'all know, the other night I went over the state's response to the mistrial motion, right? Well, the defense has or will be submitting a reply to that motion, okay? And they saying a lot of shit up in their motion, okay? They calling out Brady violations and even a structural error. Okay. Now, for those who have followed me with the Miller case, you know Brady violations is definitely bad. However, as far as mistrial purposes, you know what I'm saying? It got to be real, like, to show like some innocence or something for it to really, you know what I'm saying, make a difference. But structural errors is something that's a whole different ball game. Okay. And we're gonna get into it because I'm gonna be honest. I just learned what the hell that is today. I had never even heard about it until today. Okay. So I had to do my homework a little bit. Okay. So I can know what the hell is it talking about. Be Shield, what's up? Happy New Year. So again, y'all, if y'all just join me, I have the flu, so your girl down bad right now, but we're gonna get to it. All right, so let's just start. Pull up my phone. Let me just start with. All right, let me see what part I'm gonna start with. All right, so again, Kenneth Robertson, aka Kenny Mac, that's the defendant that is filing the motion for mistrial. Okay, his lawyer, okay, or his legal team filed a reply. I believe it got filed this weekend. And yes, I do have a copy of it because obviously I'm included in it. Okay. It's something about December. Last year I had COVID in December. It's just something about December. So yeah, I'm not turning up for nothing tonight. I had to cancel my party. Okay. All right. So in this motion, again, it's a reply in support of the motion for mistrial. It's stating here that the mistrial filed after a member of the media was excluded from watching some of the cross-examination of Rakeem Woolton. All right. So first and foremost, they are saying that I was wrongfully removed or excluded from the courtroom. Their stance is that although the government is saying it's a safety measure and all that, in a nutshell, they say that's cap. It had nothing to do with no safety measure because I, Mickey Truth, did not do nothing to the the witness. Everything was towards me. So it wasn't a safety measure. They saying it's impossible for whatever credible threats he was making for the government not to control him or something along that line. I'm doing a summary, okay? Now, the situation is that the government is wanting to say, hey, Mickey Truth is not even media, okay? She's not part of the newspaper, Chicago Sun-Times, places like things like that. The defense argument is YouTube or bloggers are modern media. And the reason why, and this is according to the document, their stance is the reason why Corroborator 3 was so angry towards me is because I target his audience, meaning we both on YouTube. We're both have the same type of viewers. And that's why, he was upset with me and wasn't upset with, say, Chicago Sun-Times, Chicago Tribune, things like that. In a nutshell, basically, I will be reporting on things that we want to know, like as people on YouTube, compared to like a news article, probably gonna omit some of the stuff that we may think is important. Hold on, y'all. All right. So, all right, let me see. Now, this part in it is this because again, on the response that the government made that everybody was running with, they're like, oh, I, among other YouTubers, made videos about the identities possibly of cooperators in the case. So let me read to y'all this. All right. It says the government has offered nothing from anyone that disagrees with Ms. Williams' declaration. It is uncontroverted. I can't even say it. It is uncontroverted. Okay, I had to break that shit down. It is uncontroverted. If this were a civil dispute, the court would grant summary judgment finding no relevant facts are disputed. Now, this is what they're saying as far as that document 418. The defense is saying the government has responded by making a passive attempt at obtaining approval for the exclusion. Okay, it says that again, they mischaracterized the dispute as being of a picture being posted of Wilson's mother, although it knows that never happened. There is no evidence that any photo was ever posted before Ms. Williams was excluded. It once described the issue as doxing and now does so again, a made-up allegation without evidence. So, Tony Snow, what's up? So, their stance is now, after again, the government has responded. So now they're going after the government response. They're saying, hey, originally y'all said that the blogger was a security threat because the blogger being me, because I was doxing Corroborator 3 mom or family, right? Then they're like, but then y'all say, oh, it's about the comment that she made, that she went back and did a retraction of the 2700, right? So they said, but in your response to the mistrial, you're saying it's a photo. That is no proof I ever showed the photo, which I done said multiple times. I never shared a photo, posted a photo of that lady, right? So, that's their grounds, right? Then it says, the false narrative does not, in the end, matter. The government does not dispute Ms. Williams' version of events. It does not dispute that she had been in communication with Wilson's mother and that the communication were always friendly and amicable. It does not dispute that Wilson's mother contacted Williams to advise her that no one in her family had been paid to testify, or that Williams published a timely correction. Nor does the government claim to have found or ever been aware of any evidence of misconduct by Williams or any evidence in support of Wilson's statement that Williams had posted a picture of his mother. The government does not claim that there was security emergency, which somehow excuses failure to seek court approval as required by law. The government does not dispute that it acted because Wilson was upset, not because Williams did anything wrong. Simply, the government fails to reveal any factual support for Williams' exclusion. Now, I told y'all the big thing is, if it wasn't grounds to have me removed from the courtroom, that violates, again, my First Amendment rights, which in return will violate the defendant's Sixth Amendment rights. So in this reply, they're basically saying, hey, y'all said all this in that reply, but you still have not provided any factual support to the original allegation. So unless it went over somebody here, I'm just going to say it for those that may have went over their head before, the court did not, the judge did not rule for me to be removed. The U.S. Marshal Service did it on their own regards based on what Corroborator 3, aka FBG Butter, had going on. The judge never ruled on it. And like I told y'all from day one, before I even knew all the details of what was going on, I said I hate that it happened once I got in the courtroom, because at that point, that's what makes it a problem. If I was stopped outside, it wouldn't be this big of a deal. But because I was sitting in the courtroom and, again, witnessed by everybody being removed out the courtroom, that's what's making this situation so major. And again, for the defense, it's definitely major, because when you get into Constitution violations in a court trial, yeah, okay. So let's keep going. So they further go to say the witness was upset about something that never occurred. And it says, what really sparked his paranoia is immaterial. That the marshals and agents, government actors, knew that Wilson's allegations was untrue is an important fact. Claims that the government wanted to remove Miss Williams for her own safety are pretextual. This removal of a member of the public and press was really an attempt at pacifying the government witness. The real reason Ms. Williams was removed was because the government wanted to hide Wilson's unprovoked rage from the jury to avoid scrutiny. The court and the defense were told of a non-existent threat or other malfeasance, something that the government actors, prosecutors, and or marshals who were present knew or should have known was untrue. So to break that down, it's basically, again, FBG Butter lied, point blank period, okay? He lied to them people saying I was doxing his mama, sharing pictures and all that shit. His mama lied, however y'all want to word it, it was a lie. Like I told y'all before, it's transcripts to this, okay, that outline all this shit, okay? The government stated that because of that, that is why he was so upset or whatnot. Come to find out, obviously, like I said, once you do your homework, you'll know I ain't never shared no pictures or nothing like that. So in the government's response, again, they don't even address the fact that you know, they never found no picture. They just went straight into, well, back in August, among other YouTubers, you know what I'm saying, she made a video about the Lil J case and all that with FBG Butter. But they still don't address, again, the foundation of this whole situation was the allegations that FBG Butter said that I was doxing his mama, sharing pictures of his mama, or whatever. They don't address that. But what they do say is my statements are consistent and that they have reviewed my YouTube. They said it in the paperwork. They reviewed it. So again, I mean, I'm gonna be honest. This reply, this rebuttal, or however you want to put it, from the defense, definitely makes sense. I'm gonna be honest. But we gonna get into it. You know, like I said, y'all, I got the flu, so I ain't gonna be on here long. But it's a 23-page document, so I'm just summarizing it. It'll be probably published sometime next week, once the holiday go out, if it's not already. But like I said, I got it from the defense because I am listed in it. So again, that's why I got it now. And I believe the Chicago sometimes got it too. So I'm not the only person. Before anybody try to run that narrative, the news outlets got it too. Okay, let me see. All right, so they say this right here. Okay, 6 feet, let them know. Thank you, 83. I don't even know my photo, but I appreciate it. All right. So it then goes to say Mr. Robeson understands that there will be great reluctance to admit any mistakes were made. After all, the court and the parties have invested thousands of hours and months of time into this case. No one wants to have to redo, but it is unfortunately what the law requires. Too legit, what's up? So basically they're saying at this point, for the legal stance and all that, it has to be a mistrial. And I'm about to get into why they're saying it has to be a mistrial at this point. Okay. Thank you, 83. Oh, y'all. I can't even breathe. Okay. Let me cut this humidifier on. I can't even breathe. All right. Thank y'all. Thank you. I hope this go. Like, my body feels so weak. All that. Okay. All right. So I'm not gonna get into the background because we just went over that. But they do summarize this, that again in document 418, they provide a affidavit from the Chicago police officer, and they said even with voice box, what's up? Even with the Chicago police officer affidavit, she doesn't say anything that like says what I'm saying is not true, and that's basically what they outlined in that too. Because it says. It says the affidavit continues. Other agents involved in the proceedings had also seen a posting understood to be posted by Ms. Williams on the internet and knew what Ms. Williams, looked like. Revealingly, the affidavit does not claim the other agents who had seen the posting had seen any photo of his mother as claimed by Wilton, likely because there was no photo or identified anything improper. Ms. Williams had published a discussion of the previous day's testimony, and that is what the government investigation, if any, confirmed. Hold on, y'all. I am going through it. Y'all bear with me, okay? Hold on. Okay. All right, let's see. They go into saying again that the Brady violation, according to the defense, is that the government did not tell them about a credible threat to the court, meaning that LPG Butter was a credible threat. Like, he was the threat. It wasn't me. According to this document, they basically try to, again, y'all, for those who don't know, me and Sandy Nash situations happened the same day, around the same time. According to the document, basically, they referred to the other blogger that they basically put on record to the judge that was a threat, and try to like slide my situation in there too without making it separate. So the defense is like, yeah, hey, y'all ain't even tell us it was no threat to the court. That should have been disclosed to us. So they said that is the Brady violation. They're alleging that the Brady violation is that the fact that the government did not say LPG Butter was a credible threat. And they then go to outline how was it going to be possible for LPG Butter to carry out whatever it is he was supposed to do to me while I was sitting in the court with all the agents and people around. So they said so it couldn't have been no safety threat, because how was he gonna get through everybody to do it? That's basically in a nutshell what it says. It then goes to say it is troubling that Ms. Cohen, which is the officer who did the affidavit, confirms that at least one AUSA was aware of Wilton's threat. The government did not share the information with the court or the defense. Thus, the court was deprived of any opportunity to weigh in on the exclusion, and the defense was deprived of valuable Brady material. Yeah, I've been sleep all day. Like, I had got this earlier, and I've been saying I was gonna do a video when I wake up. I've been asleep all day, and I said, let me just go live and get through. So yeah, I'm gonna probably do some tea in a minute. All right. It then goes to say, the government goes through a long-winded discussion of the case while complaining about others who have not been allowed to attend, also without the defense's knowledge, as if they were somehow relevant. It includes irrelevant references to the attempted identification of certain corroborators, but the government does not suggest attempts to identify witnesses are illegal or improper, just something they did not like. Nor does the government point to any instance where a witness, Wilton included, was threatened or in danger. How could they? This is what it says. Okay. Their own corroborators were posting videos and out in themselves. Wilton was on YouTube talking about his testimony while he was still testifying. The government also cites the heightened security concern relating to the trial. The claim turns the issue on its head. Any security concern did not originate from Ms. Williams or any other spectator. All concerns originated with the government witness. The courtroom has been a safe environment. All who enter are required to go through the building inspection, which includes metal detectors on the first floor, again through a separate security checkpoint, including a second metal detector outside the courtroom. Spectators are required to deposit any cell phones or other items into a locked box outside the courtroom. It says here the government was pacifying an out of control childlike witness, one having a meltdown by removing Ms. Williams, and it was means to an end. Ms. Williams' exclusion was bad parenting. Oh, that's been a long time. I can't breathe. Okay, give me 1 second, y'all. All right, let me try. Let me try to go move a little faster. All right, so now we about to get into. Okay, they get into the Sixth Amendment. How this is in straight violations of Mr. Robinson's right to a public trial. I'm scrolling through. All right, here you go. It says, even now, the government has not attempted to show any overriding interest that was likely to be prejudiced absent closure, and that closure of the courtroom was no broader than necessary to protect that interest. The government confesses error when it fails to address the requirements for exclusion of the public. The idea that a member of the public and press can be excluded from a public trial because a witness is upset about the member's presence is a what? I don't know what the hell that word is, of a public trial. In a public trial, witnesses must testify in front of everyone, friend and foe, those rooting for the witness, those rooting for the against. When a witness, whether through a demand or behavior, can dictate who is allowed to observe the trial, we have eroded the idea of a public trial. Okay, so let's keep going. Then they go on to say, mindful of their shallow position, the government analysis misses the point. It relies upon cases in which a court approved the closure in advance, rather than those where the court was not asked. While the government seeks to explain the events and have after-the-fact approval, the case requires the trial court to conduct a hearing before any conclusion and to make findings as prerequisite. Thus, the government cannot cite to this court a single case when exclusion properly preceded court approval, nor does the government cite any case where the government had the power to temporarily exclude an observer without court approval. This is understandably, there are no such holdings. It is too late for the court to assess the factors and determine it would have agreed whether this exclusion from trial is a structural error. All right, now this is what I told y'all was new to me. I had never heard of it. But this shit get deep. All right. Let me put this up. So they actually cite this in the paperwork, okay? And it basically says here, the U.S. Supreme Court held that structural error requires a showing of prejudice when raised via an ineffective assistance claim. The decision provides clarity regarding the intersection of the doctrines of structural error and ineffective assistance of counsel. Let's see. Hold on. That's not a good one. Okay, I'm just gonna read from what they said on the paperwork because it's elaborated better in the paperwork. Hold on. All right, so this is how they got it worded in the paperwork. It says, on review, an appellate court can determine that the trial court did not err in excluding somebody after a hearing, but an appellate cannot find that the trial court would have acted properly if it had considered the issue. The same is true of this trial court. No court has upheld exclusion absent pre-exclusion consideration by the lower court. Knowing all of this, the government surprisingly relies on Wilson versus Bradley. There, the court was evaluating whether a state court trial, much of which had been being held during late evening hours, would, when the courthouse was closed and the public could not enter, violated the defendant's right to a public trial. So basically, going at all the case precedents that they put in there. Then it says the government merely and only suggests that Williams' previous attempt to speculate about the identity of government witnesses pose a safety concern, a new reason that is not contained in Coy's affidavit. It is an incredible claim. The government never asked the court to exclude anyone from the trial for that reason. It never requested that if Williams came, she be barred. How could it? There is no legal connection between pretrial speculation as to a witness' identity and observing their public testimony. And the discussion of Wilson's testimony after he had publicly testified could not have provided a reason for exclusion. For those, okay, that keep saying that shit. I have to keep telling y'all, you know what y'all talk about. You can talk about it. But anyway. All right, let's keep going. Oh, here we go. Now, this is it right here. The government knew that it needed the court's approval before exclusion. After all, virtually with this exclusion indeed preceding it, the government sought the court's blessing when another individual was barred. So, like I told y'all, Sadie Nash, like they had got approval for Sadie Nash not to be allowed into the courtroom. While the government apparently was unaware of the procedure that needed to be followed before then, the defense was, and in that case, it saved the government from itself. But having been spared that time, the government then concealed the exclusion of Ms. Williams from the court and the party. Simply, the government did not want to risk their witness acting out in front of a jury or their testimony being restricted, so it made the decision that Ms. Williams had to go. So, thank you, 83. So, in a nutshell, they basically saying that, like I told y'all, how it was worded was definitely they was mixing in me and setting that situation, but indeed they were saying it was a security issue on my end, but in reality, the security threat was goddamn Butter, not me. So now the defense is outlining that, like, hey, y'all got permission for the other blogger, but y'all hid the fact that y'all asked Mickey Truth to leave the courtroom. And I believe they said like they didn't know they was asking me to leave, that it was the U.S. Marshal decision to do that, something along that line. All right. So then they go to talking about basically, like I told y'all, that being that I'm a YouTuber or blogger, that's not considered media. And they go into their argument on how that is not true, especially now where majority of people in modern time comes to social media and things like that for their news update. Okay. And then they said if it was really an issue, then the witness would have stated it the first day I was in court, not the next day. They do bring up the fact that their belief is that Butter was mad because I was on 16 Shot Him. And I agree with that. I think being that I got on 16 Shot Him to talk about his testimony pissed them off because, that's a Chicago platform. And, him and his deflection, okay? But, yeah. So they talk about that in there. All right, hold on. Ooh, yeah. Y'all, my body. All right, what's this? And oh yeah, and then they go on to say they cannot say. So basically, the government was saying, "Hey, the witness acted the same way whether Mickey Truth was in the courtroom or not, or Miss Williams, right?" The defense is saying that's cap because we won't know what the witness would have acted like because y'all removed her from the courtroom before he came in there. So they're using that as grounds too, because they're saying, hey, you can't say, you know what I'm saying, what was going to happen because I wasn't, she wasn't in there when he came in there. The jury got to see, again, a calm version of the witness compared to how y'all saying and all that he was doing, running down the steps and shit, that he would have been on a different level if I was in the courtroom. So they're using that too. They also called the government out for not saying how did they calm the witness down. The defense says they feel like they told him I wasn't in there no more, and that's what calmed him down, which again is playing into the notion of they removed me just to pacify the boy. But all right. They then go into talking about my YouTube. They said even if the burden was not on the government to meet their argument that was trivial is ridiculous. Ms. Williams is a member of the modern media. Hold on, y'all. I got to blow my nose again. Y'all be careful out here, okay? Because this flu shit here. All right. It goes to say her video reporting on this case has garnered thousands of views. As the government writes, a key focus of her reporting on the case related to Rakeem Wilson, who was previously identified as corroborate number 3. She traveled to Chicago to provide on-site reporting relating to Mr. Wilson's and others' public testimony. The fact that the government believes she is not media is just plain wrong. After Mr. Wilson saw this reporting in a courthouse, he had what can only be fairly categorized as a tantrum, yelling at the government and running out of the witness room. He ran down the stairs from the 25th floor, presumably heading out of the building in the middle of his testimony before being stopped by Chicago police detectives. While the government asserts that law enforcement managed to calm him down, it does not provide any information on how they regained control of their witness. The only logical explanation is because they likely told him Ms. Williams was gone from the courtroom and thus would no longer be able to go on YouTube to let her viewers know what he was saying. This pacified Wilson because he did not like what she reported. More specifically, he did not like who her reports reached. After all, she went on the same podcast he went on moments after he did, in the middle of his testimony. Plainly, the appearance is what sparked his anger. Had it not been, he would not have raised the issue. He would have raised the issue the first day he testified when Ms. Williams was present. Instead, he threw his tantrum the morning after their back-to-back mid-testimonial appearance on 16 Shot on YouTube page. Mr. Wilson wanted to be the person who controlled the public narrative about what he was testifying to. This is why he brazenly violated the court's order to participate in an hour-long video interview about his testimony that garnered more than 100,000 views. The clips from it have also been viewed over 100,000 times. He was upset that Ms. Williams was reaching the same audience that he thought he planned to manipulate. This conclusion only became more obvious when Wilson went back on the podcast the next night, immediately confronting the host for having her on. And they go into like the transcript of him and 16 Shot on conversation. Oh, I can't breathe. All right. They then goes to say, like, you can't separate her being a blogger or a YouTuber and compare it to like Chicago Tribune and all that, because it says that a member of the old-fashioned media was still reporting was not Mr. Wilson's concern. He was not running through the halls of the courthouse yelling at the government about the Chicago Tribune or Sun-Times reporter or about local TV. Mr. Wilson was concerned about a member of the new media, something he is well familiar with. It is his livelihood. He is self-proclaimed king of YouTube, having morphed his life and image as a criminal and gang member into content creator of the same things. Wilson knows the traditional news, print media, and the 5 o'clock news are not where the audience he targets get their information. He focused on those who look to YouTube, Facebook, Instagram, Reddit, and other online media to obtain information, particularly the set of social media that flocks to the internet to satisfy their infatuation with this case and Wilson's type of lifestyle in Chicago. His reputation and the money he so proudly boasts about earning as king of YouTube depend on maintaining his criminal and gang member reputation. Yeah, I can't make this shit up, okay? Then they say last, government claims that Ms. Williams is not a media member and thus her exclusion was trivial. Is demeaning at best, not just to her, but to the people who provide information in online and streaming media. The government has seen what she reported and it does not challenge her accuracy. She is a working journalist. The government argument relegates to lesser status of an entire group of millions of people, all of races, classes, and cultures, because of their online method of consumption is in view somehow inferior public. Yeah, I can't. Okay. I'm gonna skip that. Okay. It say Ms. Williams traveled to Chicago, watched the trial, then she told people what she watched. That is reporting. it has always been what reporters have done. View, invent, and explain it. Here, because Wilton did not like how close to home the reporter's reach was, the government prevented the reporting from happening. Again, the fault is of no consequence nor prejudice, which is clear. The fact of the matter is structural error occurred, and because the government cannot go back in time and ask the court for permission where it did not, the error cannot be cured. Okay? So basically, they're saying the government fucked up because by law they were supposed to get it approved by the judge to have me removed, which they did not. Although they're saying the marshals did it without their knowledge. Now, this is the kicker. The conclusion of the document says this. For all these reasons, the defendant respectfully requests an evidentiary hearing of the exclusion, that the court order the impound of the law enforcement electronic messaging of this subject, that a mistrial be granted, and for all such further and other relief as the court deems just and appropriate. Ooh, that's a lot out of me to get that through that paper. Like I say, it's 23 pages. I summarize it because obviously I can't breathe. Okay. So it's, hey, yeah, I don't even know. You know, that's crazy. Like I said, and you're gonna have the people that's gonna want to say whatever they want to say about the situation. But this all started, the paperwork to prove this all started because FBG Butter wanting to lie and get emotional. All this started because of that. The same people that's in his camp that been bashing me all this time, instead of saying, yo, hey, Mickey, you might want to just chill out, don't go in there. He on one, you know what I'm saying? Like, whatever. Because like I said, I would have left if somebody would have just said what type of time it was, you know what I'm saying? Because I know whatever happened in a courtroom can't play a factor. Even his manager that morning said, nah, everything was good. So, again, it all started because cap ass Butter want to do all this fucking emotional ass weird shit. Now this shit is a bigger situation. For those who's wondering, again, I said in the beginning, why I'm the one at the center of it and not Seti Nash, because Seti Nash never made it into the courtroom. Like I said, if I never would have made it into the courtroom, okay, then it wouldn't have been no issue. But because I literally was sitting in them for about 20 minutes and everybody saw me removed, that's the problem. Because now they're like, well, hold on, we saw her get asked to move. Now, even the officer that did affidavit said, hey, I saw her get approached and then escorted out. So at that point, that's what makes this a constitutional issue because the court, again, did not approve my removal. So now the question is, well, who the hell told the marshals to remove her? Hold on. Oh yeah, I got the flu, y'all. What's up, Roberta? Yeah, I got the flu. I woke up yesterday morning, like feeling like shit, like a pound of bricks was on me. Ugh. Okay, so I mean, yeah. Oh, say please move on to something else. Well, I got you. Say less. Listen, let me say this before I get up off it, okay? At the end of the day, at this point, y'all can't tell me not to talk about it. My whole fucking name is up in this bitch. So y'all love to say talk about it. You ain't got nothing to do with it. Well, at this point, okay, thanks to FBI Butter, I do got something to do with it, okay? So because my name is in it, and not no fucking just no make it true, they got my whole fucking name in that shit. What happened to me is the basis of this shit. So again, if you don't want to hear it, then get the fuck on. Like really. Now, I came on sick and all because, like I said, it's not even out yet, and y'all know I like to let y'all know what's going on in advance. People start probably running it next week sometimes and putting their spin on it. Shut up, music. But yeah, so that's pretty much what's going on. So I don't know what's supposed to take place at this evidentiary hearing. If it gotta be, I don't know what the fuck. All I know, they better cough up a picture somewhere, because the whole basis of this whole situation was that FBI Butter said I shared a picture of his mama. So again, like, they better cough something up, because right now, look, it is y'all capping. This whole thing alleged. Now, at first, the whole narrative was about, and I did find this out. The defense is the one that used the word erroneous. Okay. I got a theory to why they use it, but I don't know. I'm not gonna speculate. I'm just gonna say, so the defense is, I thought the government said it, but the defense said it was erroneous. So, but because they say it again in this document. But this is crazy. And I'll be honest, this whole situation is crazy, because even before I went into that courtroom, everybody know. I done said it even watching court. Like, everything that happens inside a courtroom is grounds for anything. Like, you don't supposed to let nothing happen inside that courtroom. So the fact that these people sat by knowing that the weirdo was doing weird shit and not say nothing, that's crazy. Okay. For sure. So it's like, that's crazy. Like I said, a structural error. Oh, and then what I was trying to find, because basically what I was looking up, and y'all can look it up. This is the Weaver versus Massachusetts. Like, that shit serious right now. Like, even if it don't get a mistrial, they can fucking take that shit later on to the appellate court and get the whole fucking, if they got convicted, thrown out just off of that. That's why they're saying, yo, well, we need to have this evidentiary hearing. Y'all need to show us proof of the allegations made by y'all witness, where Mickey Truth, you know what I'm saying, did the doxing or whatever, where it would have been grounds that she was a security threat. Because in actuality, he was a threat. I mean, even by the government and the officers, he was a threat. So this shit crazy. This crazy. Okay. So that's just where they're at. So they're basically asking the government, like, hey, y'all said all this and that based on y'all witness. Okay. Y'all need to provide the evidence for it. And they're asking now for somebody trying to run with that. They're asking for the government to provide their text messages and emails and all that about the situation surrounding my removal from the court. Not me. Okay. They want their shit. But shit, even if they didn't want mine, you can have that shit. Fuck, because I ain't did none of that shit they accused me of. But with that being said, that's it. That's pretty much it. That's what's going on. They set to, like, I think this is set to go to the jury, but they gonna have to figure this part out first. You know what I'm saying? What's what? I ain't gonna tell you no lie though. If the judge ruled that in fact I got removed for no cause, I'm suing their ass straight up. I am getting me a lawyer. I'm suing their ass. Somebody give me a good Chicago constitutional lawyer. I'm telling you, if the judge ruled that I got removed for no cause, I'm suing their ass. Sick and all, okay? Sick and all, okay? Call it what you want. You fucking right. If that shit get ruled that way, I'm suing their ass. For real, for real. And they can clip that part. Hell yeah. Okay. What it do, Loud Pat? But that's pretty much it. Y'all got any questions about this? If not, I'm about to get up off here. I'm telling y'all, man, listen. It's crazy though. And like I said, it was so much commotion that day. I ain't gonna tell y'all no lie. Man, the government lying. They knew they was about to get my ass up out of there. And then they said that I was being interviewed. Them niggas ain't never interviewed me. Shit, the hell. Talking about they interviewed me about doxing. No, the fuck y'all did. Y'all ain't mentioned none of that shit. I ain't hear that shit to the damn defense. Hit me up, talk about some fucking docs. I'm like, who the fuck got docs? Y'all, I'm over here drinking orange juice, right? And I can't breathe out my nose. Whew, so I had to hold my breath while I drank my stuff just now. Okay, I got you. So yeah, y'all. So it seems like y'all don't have no questions. I might get up off here. I'll be honest. I was supposed to be back on the pavement at the bar, but I ain't about to do shit until I feel better. So this might be the last video y'all get for a couple days until I feel better. Because baby, your girl, like, I ain't about to even get on camera. My eyes look crazy. My nose look like it went up. I already got a little plump nose. My nose look like it went up about 10 sizes. Okay. I look bad, feel bad right now. Okay, thank you, Roberta. I have never, ever had the flu. This shit got COVID beat, if you ask me. I done had COVID 3 times. But this shit here, this shit different. This shit different. Hell, I'm not doing no nasal spray. Like, my nose already got enough liquid in it. Oh, I will say this too, though. As far as the YNW belly case, 1090 Jake YouTube videos all up and through that. I said, not you in the belly case. That shit crazy. But yeah, y'all, I appreciate y'all for pulling up. I hope y'all have a safe evening. Happy New Year's in advance. I'm about to be asleep, okay? Oh yeah, that humidifier working. Cause now my nose running. All right, yeah, I got to go. I appreciate y'all. Listen, 2022. I told y'all we gonna go up a couple notches in our value. 2023, we was on a fucking next all year. So I'm gonna say this, okay, True Team. 2024, man, ain't no stopping us for sure. Ain't no stopping us, okay? We out here for real. Now I sound like Squidward. You know what, Loud Pet? I'm about to go because I think this humidifier is working because, like, it's starting to drain, okay? But happy New Year's, y'all. Like I said, as soon as I feel better, I'll be back on here. Be safe. Mickey True about to be in the bed, okay? Ain't no nothing going on over here. I had to cancel my whole party, but I'll talk to y'all in 2024. Holla!